and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about insurance and knowledge. Cases that should have gone to the Supreme Court of Canada, but didn't. Ashley Cardinal was a passenger in a vehicle that was involved in a collision. Unbeknownst to Miss Cardinal, the vehicle was taken without the consent of the owner. When she was injured in the collision, she filed an insurance claim, and her insurance claim was denied on the basis of the fact that the vehicle was being driven by somebody other than the owner, and therefore she wasn't insured. She was left to pay out of pocket for her injuries. To any reasonable person, what happened to Miss Cardinal is extremely unfair. To any reasonable person, you would assume that she should have to have coverage for that type of a collision. But unfortunately, the Court of Appeal didn't think that she did, and interpreted the Quebec legislation and the Quebec insurance about this as not in Miss Cardinal's favor. This case raises very important issues of fairness when it comes to insurers, and what the importance is of knowledge about the status of who is owning and occupying a vehicle. It's not reasonable to expect drivers to tell their passengers whether or not they have the vehicle with the owner's consent, particularly in circumstances, as in Miss Cardinal's, where that vehicle has been taken without consent. Nor is it reasonable to put a burden on passengers in vehicles to make inquiries to determine whether or not the vehicle belongs to the person who is driving it and whether or not they have it with consent. That's imposing a burden on people to predict the consequences of somebody else's actions in the event that they're injured, and something that seems inconsistent with ordinary human life. And I think the Supreme Court of Canada missed the opportunity to ensure that an insurance scheme meant to protect people who are innocent victims of bad drivers and lawbreakers has failed in that regard and failed to protect the rights of individuals. It opens the door for abuses by insurance companies in permitting their insurance policies to prohibit coverage for people who are simply innocent victims in somebody else's criminal or otherwise unlawful activity. Unfortunately, the Supreme Court of Canada didn't take this opportunity to make things a little bit more fair for the little guy when dealing with the big insurance company, and that's an unfortunate situation that hopefully they'll rectify another day. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Brazen Bull Creative has put together these videos, and I hope you tune in next week for another exciting episode.